This is the lecture series on the topic of bringing legal representative of deceased party on record. Regarding this main topic, I have divided this main topic into various subtopics, and in respect of those subtopics, I have already delivered 5 lectures, and I have delivered and uploaded 5 different video parts so far. So I request you, please also watch those earlier 5 video parts which are with respect to the lecture on the subtopic of the main topic relating to bringing legal representatives of the deceased party on record. Today I will discuss the topic of subtopic bringing legal representatives of such defendant who died prior to filing of a suit. Bringing legal representative of such defendant who died prior to filing of a suit. To discuss this topic, I will take help of one reported judgment of Madhya Pradesh High Court. The citation of this judgment is year 2001, All India High Court, page 317. This judgment is given by the High Court in the civil revision petition. The parties before High Court in this revision petition is Shrimati Agarwal, who is a widow of one G.S. Agarwal. She is the petitioner applicant in this revision petition, versus Arya Vidya Sabha. So it is a society, Arya Vidya Sabha. That Arya Vidya Sabha is opposite party in this revision petition. The facts in brief of this case is as under: that Arya Vidya Sabha, it is a registered society. That Arya Vidya Sabha is the owner of one premises. That Arya Vidya Sabha is the owner of suit premises, and that suit premises was given on rent basis to that Shri G.S. Agarwal. So that G.S. Agarwal was the original tenant of the tenanted premises, suit premises. But that G.S. Agarwal, who is the original tenant, he later on gave that tenanted premises to his subtenant, and therefore that tenanted premises, that is suit premises, it was in actual possession of subtenant of that G.S. Agarwal, and therefore this Arya Vidya Sabha, that society, filed one suit in the year 1995 for the ejectment of that subtenant who is in actual possession of that tenanted premises. That suit was filed against the two defendants. Plaintiff filed that suit against the two defendants. First defendant is that Mr. G.S. Agarwal, who is the original tenant of that suit premises. He is a defendant number 1 in the suit, and that subtenant is a defendant number 2 in this suit. So subtenant is a defendant number 2 in this suit. After filing of this suit, after institution of this suit in the court, when that suit was pending, that plaintiff Arya Vidya Sabha, that plaintiff society came to know about the fact that said Mr. G.S. Agarwal had died long back. But while filing the suit, while institution of this suit in the court, plaintiff was not aware of this fact that G.S. Agarwal, to whom the plaintiff has made defendant number 1, he has died long before. Then after coming to know about this fact that G.S. Agarwal had already died, that plaintiff made an application to the court under under the provisions of Order 22 Rule 4 of the Civil Procedure Code for the substitution of the legal heirs of that Mr. G.S. Agarwal. But that application was objected to by said subtenant, who was the defendant number 2 in the suit, as well as that application was also objected by the legal representatives of said G.S. Agarwal, legal representative, especially the widow Srimati Agarwal, who is a petitioner applicant in this revision. So that application of the plaintiff Arya Vidya Sabha Society, application filed under Order 22 Rule 4 for the substitution of legal heirs of that deceased G.S. Agarwal, that application was objected to by the defendant number 2 and also by that legal representatives of deceased G.S. Agarwal. That application was objected on the ground that said G.S. Agarwal had expired on 15/8/1992. That is long before the filing of the suit. That suit has been instituted in the year 1995 against that G.S. Agarwal. G.S. Agarwal has been made as a defendant number 1 in this suit, but the fact is that he was died in the year 1992 itself, and suit has been filed in the 1995 against him. Therefore, it was the objection by said subtenant, objection raised by that subtenant and also the legal representative of that deceased G.S. Agarwal, that said suit had been filed against a dead person. And therefore, because the suit had been filed against the dead person, the entire proceeding is void. Entire suit proceeding is void, and in such case, that application of the provision of Order 22 Rule 4 is, this provision of Order 22 Rule 4 is not applicable in this case. The trial court has accepted this contention made by the defendant number 2 as well as by the legal representative of that deceased G.S. Agarwal. Trial court accepted this contention and rejected that application for substitution of legal heirs, that application which was made under the provision of Order 22 Rule 4. Thereafter, that plaintiff, that is Arya Vidya Sabha Society, who is the owner of tenanted premises, that plaintiff filed one another application, but now under Order 1 Rule 10 Sub Rule 2 of the Civil Procedure Code, and prayed for bringing legal heirs of the deceased G.S. Agarwal, prayed that legal heirs of the deceased G.S. Agarwal be added as parties to the suit because they are necessary parties in this suit. That said application, another application made which was made under Order 1 Rule 10 Sub Rule 2, that said application was also objected to by the subtenant. The contention of the subtenant is that, for raising such objection, that once the application to bring the legal representative of deceased G.S. Agarwal had already been rejected, then it cannot be allowed under Order 1 Rule 10 of the code. So what is the objection? Already court has rejected the application of plaintiff to bring the legal representative of deceased G.S. Agarwal. Therefore, plaintiff cannot make this another application again under the provision of Order 1 Rule 10 of the code. But now the trial court did not accept this contention, objection raised by this subtenant 2, who was the defendant number 2 in the suit. So trial court did not accept this contention that filing of suit was ab initio void. Trial court did not accept this that contention. And what is the objection regarding making such filing of suit as void? On the ground that the legal representative could not be brought on record under Order 1 Rule 10 of the code because the application under Order 22 Rule 4 of the code was already rejected earlier. But the trial court did not accept this contention, and trial court directed that the legal representative of that deceased G.S. Agarwal to be brought on record, and because of this order of the trial court, feeling aggrieved by this order, the legal representatives of that deceased G.S. Agarwal filed this present civil revision petition before the High Court. Therefore, in this civil revision petition, Srimati Agarwal, who is a widow of that deceased G.S. Agarwal, is the petitioner. And who are the opposite parties? Opposite party number 1 is that society, Arya Vidya Sabha, who is the owner of tenanted premises, and opposite party number 2 is that subtenant in this revision petition. Now, this matter came before the High Court. So before the High Court, the point for consideration is whether the court had jurisdiction in the facts of the case to entertain an application made under Order 1 Rule 10, Sub-Rule 2 of the court, after already rejecting the prayer under Order 22, Rule 4 of the court. So this is the moot question before the High Court. In this respect, it is relevant to see the provisions of Order 22, Rule 4 of the court. It gives the procedure in case of death of one of several dependents. So this provision says, where one of the more dependents dies and the right to sue does not survive against the surviving dependent alone. When one of the two dependent dies, and right to sue does not survive against the surviving dependent alone, then the court, on an application made in their behalf, shall cause the legal representative of deceased dependent to be made a party and shall proceed with the suit. Now, here what is the suit? Suit is for the ejectment of that subtenant who was in actual possession of that tenanted premises. But can it be possible to file a suit directly against that subtenant? No, because that subtenant has derived the tenanted rights from the original tenant. Original tenant is Mr. G.S. Agarwal. So it is necessary first to make dependent number 1 to that original tenant, from whom that subtenant has derived that tenancy right as a subtenant. Therefore, in such case, it is not the case that a suit has been filed directly against the subtenant. Now, for the timing, we presume that at the time of filing of this suit, that original tenant was alive, that Mr. G.S. Agarwal was alive. And during the pendency of that suit, G.S. Agarwal dies. Now we have to consider whether suit can be proceeded against the surviving dependent alone. See, consider the situation, dependent number 1, G.S. Agarwal, he is alive at the time of filing of the suit, and the dependent number 1 died during the pendency of the suit. Now there are second dependent, subtenant. Now we have to consider whether right to sue survive merely only against that surviving dependent who is a subtenant to? No, because he has derived the tenancy right from the dependent number 1. Therefore, it is necessary after the death of this dependent number 1 to bring the legal representative of the deceased dependent number 1 on record. Then only right to sue survive against all of them. Therefore, in such a case, since the right to sue survive not alone against such dependent number 2, but right to sue survive against also the legal representative of dependent number 1, therefore it is necessary to bring on record the legal representative of the deceased dependent number 1 on record. But in our case, situation is little different. Although the dependent number 1, G.S. Agarwal, has been made as a party in this suit as a dependent number 1, but the fact is that much before the filing of this suit, he died. So in this respect, it is a well settled in law that this rule, which rule? Order 22 Rule 4, comes into play where the death of dependent occurs in the pending suit. This rule will not apply if such death had occurred before the institution of the suit. So this position is clear. That rule under Order 22 Rule 4, this rule will not apply if such death had been occurred before the institution of the suit. This rule comes into play where the death of the dependent occurs in a pending suit. Therefore, it is the observation of the Honorable High Court in this revision petition that the provision contained under Order 22 Rule 4 are not applicable in respect of the dependent who have died before the institution of the suit. Therefore, it can be properly concluded that the trial judge or trial court, the trial court had acted within his jurisdiction when he refused to exercise power under Order 22 Rule 4 of the court. So, as per the observation of the High Court, that trial judge was correct in rejecting that earlier application made by the plaintiff under Order 22 Rule 4, because Order 22 Rule 4 is not applicable in this case because the defendant number 1 has not died during the pendency of the suit. Then once again in this revision petition, that advocate for appearing for that subtenant contended that once an application under Order 22 Rule 4 of the court has been rejected, then the court has no power to impede the legal representative under Order 1 Rule 10 Sub Rule 2 of the court. Therefore, in this revision petition, point for consideration is whether Order 1 Rule 10 of the court could have been taken recourse to, whether it can be taken help of now. So, but in our case, now regarding the application of this provision of Order 1 Rule 10, it is to be remembered that if in respect of a defendant who dies during the pendency of the suit, and when an application under Order 22 Rule 4 is already rejected, then the affected party cannot take recourse again to Order 1 Rule 10 of the court. So, for the application of this Order 1 Rule 10, there is a provision when there is a provision when the defendant has died during the pendency of suit and plaintiff has made application under Order 22 Rule 4, but court has rejected that application, maybe some on other ground, that once said application has been rejected, then in that case plaintiff cannot take recourse to the provision of Order 1 Rule 10 again. But in which situation? Where the defendant has died during the pendency of the suit. But in our case, that is not the position. In our present case, the facts are such that facts are very different. In our present case, that defendant number 1, Mr. G.S. Agarwal, had not died during the pendency of the suit, but he had already expired much before the institution of the suit. Now, it is a contention on behalf of the advocate appearing on behalf of the petitioner, that is petitioner who is a widow of that Mr. G.S. Agarwal. That advocate for the petitioner has placed heavy reliance on one decision in support of his argument, a decision which is rendered in the case of C. Muthu versus Bharat Match Works, and that judgment is given by the Mysore High Court, and citation of that judgment is All India Reporter 1964, Mysore, page 293. In that case, that Mysore High Court has held that no such substitution of the legal heirs of the deceased defendant can be permitted under Order 1 Rule 10 where there was a sole defendant. So, in which situation Order 1 Rule 10 cannot be applicable? Where there was a sole defendant and who has died. So, but this particular judgment, this particular ratio is not applicable in our present case, because in our case there was no sole defendant, but the plaintiff has made two defendants, meaning thereby the defendant number 2, who was a subtenant, he was already on the record since the beginning in the suit. Therefore, this High Court in this present revision petition, they have declined to accept that case law in our present case law of that C. Muthu versus Bharat Match Works. Why? Because it was not the intention of the plaintiff to institute the suit merely or only against that subtenant who is the defendant number 2, but plaintiff has made a suit, plaintiff has instituted the suit against the two defendants. One of them was already died, but defendant number 2 was already there on the record. Therefore, in this revision petition, it is the observation of this Honorable High Court that the matter will be quite different when there is a sole defendant. But in our case, there is no sole defendant. But when there are more than one defendant, then Order 1 Rule 10 Sub Rule 2 of the Code can be taken recourse to. So, while taking this view in this present revision petition by this High Court has also referred two case laws. This High Court has also referred two case laws in support of this view of the High Court. First case law is reported in the All India Reporter 1982, Bombay High Court, page 589. Parties are there: Navindram Jawarmal versus Dimkibai Haridas Gandhi. So, in that reported case, Bombay High Court also held that where there are more than one defendant, then in that case, Order 1 Rule 10 of the Code can be taken recourse to for the substitution of legal heirs of the deceased defendant. Besides this case law, another case law which is reported in All India Reporter year 1986, Calcutta High Court, page 227. Parties before this case are Musammat Ashagari Bibi versus Shamal Kumar. In that case, the Calcutta High Court held that in a suit where there are three joint defendants and one of them had died before the institution of the suit, then the legal heirs of the deceased can be added under Order 1 Rule 2 Sub Rule 2 of the Code after striking out the name of deceased defendant from record. That in that the facts of that reported case before the Calcutta High Court was that in that case the suit has been instituted against the three defendants, but that one of the that three defendants was already dead prior to institution of the suit. Therefore, in that case also, the plaintiff has made application under Order 1 Rule 10 Sub Rule 2 for the substitution of legal heirs. So, in that case, that Calcutta High Court held that there is no case of sole defendant who has died, but in that case there was also three defendants and one of them was already dead before the institution of suit. Then in that case, that legal heirs of that deceased defendant can be added in the suit under the provision of Order 1 Rule 10 of the Code. So, with the help of these two reported judgment, this High Court in this revision petition observed that in present case also there was another defendant from the very beginning. Who was that another defendant? That subtenant was the defendant number 2. Therefore, ultimately the High Court in this revision petition concluded that learned trial judge that order passed by the learned trial judge deserves the stamp of approval of this High Court. Means it is the observation of this High Court that trial judge has acted correctly. Trial judge has acted correctly. Initially, that what the trial judge did, the trial court has rejected the earlier application of plaintiff which was made under Order 22 Rule 4. But trial judge accepted that another application of the plaintiff which has been made under Order 1 Rule 10 Sub Rule 2. So this act of trial judge, it is correct as per the opinion of as per the observation of this High Court. Therefore, this petition which has been filed by the widow of that deceased G.S. Agarwal against that plaintiff society, this revision petition has been dismissed by this Honorable High Court, meaning thereby now plaintiff is entitled to add or to substitute the legal representative of that G.S. Agarwal as a defendant in suit after striking out the name of that deceased defendant, deceased Mr. G.S. Agarwal as a defendant number 1. So in this topic, we have considered when one can take recourse to the provision of Order 1, Rule 10, Sub Rule 2 of the Civil Procedure Code. So I stop here. I will discuss another subtopic relating to this main topic in my next video part.